This episode is based on public records, court filings, and publicly available documents and statements. All claims remain allegations unless proven in court. The content is presented for documentary and informational purposes only. The clock didn't just run out. It exposed the truth. A single date, buried in a Facebook thread from 2022, now sits at the center of a federal motion that could end Kelli Van Ginhoven's counterclaim entirely. No speculation, no guessing, just the record. And the moment it finally caught up. On June 11th, 2026, Reid Hyken's attorney filed a motion for summary judgment, and with it, the timeline snapped into place. The statute of limitations, the unanswered admissions, the First Amendment protections, all converging on one point. The law doesn't bend for convenience, and it doesn't reset for regret. Tonight, we walk through the filing that may decide the case. This is Delta Deep Dive. Now let's dive a little deeper. When the clock stopped on Kelli Van Ginhoven's counterclaim, it wasn't because of opinion, it was because of evidence. After months of filings, hearings, and motions, the record now shows exactly what happened and when. On June 11th, 2026, Reid Hyken's attorney filed a motion for summary judgment in federal court. It's the moment this case turned from argument to proof. The moment it lays out clearly. Kelli Van Ginhoven's remaining counterclaims, defamation, and intentional infliction of emotional distress hinge on one Facebook comment. The comment that said she was napping around town. The comment she claimed damaged her reputation and caused emotional harm. And now, the date of that comment is no longer in dispute. It was made on July 14th, 2022. That single timestamp changes everything. Under Michigan law, defamation has a 1-year statute of limitations. Intentional infliction of emotional distress has 3 years. Van Ginhoven filed her counterclaim on October 15th, 2025, more than 2 years after the defamation deadline and months after the emotional distress window closed. The motion cites Michigan Compiled Law 600-5805, Section 11, and Grist v. Upjohn Corporation, holding that once the clock runs out, it cannot be revived. Not by repetition, not by rediscovery, not by admission. And the law treats the claim as if it never existed. And that's exactly what Hyken's filing argues. When a right of action for slander has been once barred by the statute of limitations, it cannot be revived by an admission of defendant that he did utter the slanderous words. We have to say, Reid doesn't admit this, though. He doesn't feel it was slanderous. That's neither here nor there. That's a conversation for a different day. Let's get back to the documents. But the timing isn't the only fatal flaw. Hyken's team also served requests to admit formal questions under Federal Rule Civil Procedure 36 Section A3, asking Van Ginhoven to confirm or deny key facts. She never responded. Under federal procedure, that silence counts as an admission. By operation of law, those unanswered requests are now conclusively proven. Among them, the statements were rhetorical hyperbole, that they were made in the context of political discussion, and that she has no evidence of the reputational or financial harm. The motion cites Goodson v. Brennan and Williams v. Wells Fargo Bank, where courts held that unanswered admissions are binding and can't be undone at summary judgment. That means the record now shows that statements were opinion, caused no measurable damage, and they were made in a public conversation about a local political figure. In Michigan, that's protected speech. The brief draws on Ghanem v. Does and Collins v. Detroit Free Press, both cases where courts dismissed defamation suits over social media criticism of public officials. The reasoning is identical. Political commentary, even harsh or sarcastic, is shielded by the First Amendment. Hyken's affidavit spells it out. The purpose and intent of the July 14th, 2022 comment was to use rhetorical hyperbole to express my opinion that Vanginhoven was and is too lazy immoral, or otherwise unfit to serve on the DDA. And because Vanginhoven never contested those admissions, the court must treat them as fact. So, when the judge reviews this motion, the timeline is airtight. The post was made July 14th, 2022. The counterclaim was filed October 15th, 2025. The statute of limitations expired July 14th, 2023. The admissions confirm no damages and protected speech. In legal terms, that's checkmate. The motion closes with a simple request: dismiss the counterclaim, end the case, and let the record stand. And that's where we are now, the moment the evidence overtakes the allegation. The story that began with a Facebook comment has become a federal test of timing, speech, and truth. The clock didn't just run out. It stopped. Right on the record. This is Delta Deep Dive, and the story will continue. Follow for more.